Gangs. That was a subject of day 7 of the state of Nevada versus Dwayne Keefe D. Davis, or Keefe D. Davis, depending on the spelling variation that shows up. And for the state of Nevada, today was effectively putting on different witnesses in order to authenticate physical evidence that they want to use during the trial. How will they use it? We can't exactly be sure, but they need to authenticate that evidence in order to bring it in. Briefly, for those of you that don't know, the authentication of evidence just means bringing forward enough testimony from a person that's shown to have knowledge in order to identify the document or the piece of evidence as showing that it is what the proponent claims that it is. So if it's the state of Nevada claiming that these are bullet casings from the night of the shooting, they needed to bring someone forward that could put forth enough evidence or enough in the form of testimony that it would satisfy people that it is what they say it is, that it's not just some random bullet casings that they found outside of the courtroom. And that's what they took advantage of today in order to do. I don't know if they're ramping up for the more exciting days, but if you found today a little bit boring, noting that there wasn't any like real big breaks in evidence, that's why. So they started off with the man by the name of Malcolm Greendage, and this was actually the one witness that was there that night of the shooting in 1996 in Las Vegas, Nevada. And he was a member of the Outlaws, apparently. I wasn't a fan of the Outlaws. I don't know what his stage moniker was, but he was also a childhood friend of Tupac. Tupac put him on. He was with the Outlaws. He was in Vegas that night. He saw a shooting occur. They tried to follow Suge's vehicle. Suge tried to make an escape, make a run for it, basically. They eventually got out, caught up with him. He said he saw Tupac bleeding. Tupac said, "Hey, get down, they're going to shoot you." He turned around, he saw law enforcement with a gun pointed at him, and he got down. He does mention that there was a white Cadillac, and it seems as though the state put him on in order to put forward testimony against the notion that Death Row and Tupac were having a falling out, and hence diminish the possibility that the jury could be entertaining the theory that perhaps Suge Knight or Reggie Wright Jr. or Reggie Wright Sr. even may have been involved in Tupac's murder, because obviously Suge Knight spent millions of dollars investing in Tupac's career, and that would be a bad investment if Tupac was all of a sudden going to abandon ship. So this has more to do with theories that have popped up and circulated, which were being discussed yesterday, as a matter of fact. And we'll get into yesterday's testimony very briefly, but I want to focus on today. The only cross-examination that defense had was about the record label stuff. You know, he just got into Mr. Greendage's qualifications, and also mentioned that, hey, you said on that night that it was a white or a cream Cadillac, right? And of course the man did. This is correct. At the time, while it was fresh in his memory, he mentioned it was a white or a cream Cadillac. You know, it seems like a simple enough mistake, but this is something you're going to notice as a theme throughout the trial, and I think the defense is doing a good job of showing this by bringing up it's been 30 years. And this is a sticking point to me. Of course, not every juror is going to be like me. A sticking point to me is that this evidence was fresher a while back, like about a decade back, and they didn't move on it. They didn't move on it until what, the 4th podcast? And then they got in and decided to move on Keefe D, indict him for murder, move forward with the trial. Okay, that's great. However, you did so when the evidence became less fresh than at the first opportunity. Back when LAPD was doing their proffer, and you had Las Vegas detectives, Metro detectives right there in the room with Keefe D while he was making these statements against his self-interest. And I discussed in the previous video why that's not exactly a good description. That's a legal reason why it's being used against him, his statements. They're statements against self-interest. That's why they're not considered hearsay, or that's why they're being admitted, apart from kind of being hearsay. But, you know, they were actually self-interested statements, and I discussed that in a prior video. But just the same, now that the evidence has become more stale, years late after those admissions, now you prosecute him. So it's really hard for me to give any presumptions in favor of the state. That doesn't mean that I'm against them proving their case. It just means that when there's holes, those holes go against their case by my judgment. You know, you shouldn't be able to wait out evidence, then decide to prosecute. And we look at those holes in the case and say, Well, seems fair to me. No, it shows a lack of urgency, and it goes against your case. It doesn't go for you. That's my opinion. That's how I evaluate evidence. And the defense is doing a good job of always bringing that into the mix. Hey, your memory's not as good as what it used to be back then, is it? The next witness was an Officer Scott, crime scene analyst. Now we're getting into the gang stuff. So July 2023, he went to Henderson, Nevada to execute a search warrant, or rather to document the execution of a search warrant by law enforcement, and they used his testimony in order to authenticate some photos from the scene and from a vehicle that was around the house. There were some objections here and there, but it wasn't too eventful. Defense only mentioned to him the purpose of the search warrant, and also took the opportunity to authenticate some photos. And this was just photos of where that warrant was executed, and also of the vehicle that was there. The jury seemed a little bit confused about why he was there, because one of the questions that they were permitted to ask, they took the opportunity to try to find out, what's the point of you searching this house 30 years later? And he said, I didn't have a point. I'm just doing my job, basically. You know, I didn't ask for this. So then the next person they had put up, and I don't know if I pronounced this woman's name correctly. I heard her spell it, but the mics in the Las Vegas courthouse aren't the greatest. It's bizarre. You have all this drug and gambling money, all this prostitution money in Clark County, but your courthouse has a door that, you know, it's not even mic'd to hear the squeak, but every 5 minutes you hear this huge squeak from the door, and the mics are not mic'd well. You know, you can't hear people unless you turn up the volume all the way, and I just don't get it. You all have all this money and you're not investing it in the justice system, or at least the presentation of it. That's just me. Anyway, so I think her name is Stevie Felbone, and she's another crime scene officer that relieved Mr. Scott once he left, and the state used her testimony as an opportunity to authenticate some photos of the bedroom. Of course, the law enforcement tore it apart. Some cases, like actual physical cases, some notes, a case of Dom Perignon. There was a dresser with some medication and some books. Among those books, which the state ended up admitting into evidence, was Keefe D's autobiography in quotes, because he didn't write it. A man by the name of Yusuf wrote it. And there was also another book, Mind of a Drug Dealer. There was the Vibe magazine with Tupac on the cover. They authenticated all of it. There were some bins with personal effects that were taken by the detectives. There was a jacket, and it said Reg 64 Trays. Keefe, spelled Keefe D with a TH. Keefe D, and on it also says Southside City of Compton, and they admitted that into evidence. So the defense brings up, she wasn't there the whole time. The search had already happened by the time she arrived. He also wanted the jury to know, and got her to effectively acknowledge, that the room wasn't in this huge disarray. You know, the photos that they show, it may have well been a trap house, but this is just what the law enforcement does sometimes, so maybe all the time whenever they execute a warrant. I don't know why it's like that. I mean, be a little bit neater, but yeah, of course they tore the place up. Then the judge took the opportunity to read an instruction to the jury that this evidence was only being admitted to establish credibility. In other words, the credibility that this individual is a gang member or knows about this situation that was there. He know, taking the opportunity to establish credibility regarding the whole situation, regarding gang life, regarding Tupac and Biggie and that segment of society. This is not proof of current gang affiliation. So it's credibility regarding statements that have been made about him and statements that he made against himself in those interviews. It's not to be taken that he is a current gang member. So this instruction was granted the prior day, after testimony was taken and a brief hearing following the final witness. And it's necessary, and the defenses do it if they ask, just to avoid prejudice. So you have to ask, how much does that really affect the jury? You know, will they still be prejudiced against him as far as thinking that he is a current, you know, mob boss, current gang boss? You know, that's just it. We don't know. We're not inside that jury room, but at least one person will probably remember the judge's instruction that, hey guys, we're not supposed to use that against his current character. This is just to establish his credibility for those times that he actually spoke about in those interviews. In other words, him keeping these notebooks, him having this, Southside Compton paraphernalia shows that he knew about that era. The next person they put up was Justine Jadis. I'm not sure if I'm pronouncing her name correctly either. It's real hard to hear them even when they're right in front of the microphone. So she was a homicide detective in Las Vegas area. She executed that July 2023 warrant. She collected the bins. She talks about the time they reviewed the stuff in the vault with the prosecutor. So the stuff, all the things that they collected. She mentions that the bins were returned after they took some things out. They took the opportunity to admit a magazine with an article about Biggie Smalls' murder. They entered some police paperwork regarding a warrant. I wasn't quite clear that it was the warrant from July 2023, just about the things that they seized. Some of that seemed like it had to do with a separate Los Angeles warrant. I was a bit lost on that. So they also admitted a scrapbook with some Tupac articles, a Suge Knight article, an article from 2022 about some shootings, and they helped get some various subpoenas. They took the opportunity to mention who they had to subpoena. In other words, future hostile witnesses, witnesses that didn't come willingly. She helped track them down and get a subpoena served for them and arrange their motions to compel their appearance to testify. So they kind of already took care of that. They won't have to do like they did with Mr. McDonald, who was the grandpa Mob Pyru, and say, hey, you didn't want to be here today, did you? And have that big spiel. They went ahead and got testimony towards those points. The defense then cross-examined Ms. Jadis, goes over the procedures. He points out that they were looking for evidence of that Keefe D actually wrote that book, that Dwayne Davis actually wrote that book. Didn't find any. When it said, hey, you found all these devices, including 2 laptops. Did you find any evidence that he was involved in writing that book? No, none at all. It points out that the co-author was Yusuf Jah. He said, went about whether or not they actually took the opportunity to get statements from them. Nothing came in. In her testimony, defense points out again, hey, the investigator at the time was Clifford Mogg. He didn't write a police report about it. Well, the case was still open. They keep bringing that up, and defense is pointing this home. There was so much investigation done when Clifford Mogg was the detective on this case, and he retired without writing a report. So once again, the theme for him is it's been so long. The evidence is stale. They're putting forth a narrative that at its peak freshness didn't even exist. And now when things start changing, now you put together this narrative. It doesn't make sense to defense. Then the defense points out, so you didn't try to authenticate if he was actually in Las Vegas? No. Did you try to get a warrant to speak to Foxy Brown? No. Did you get a warrant for a big beach from Detroit? No. And she really didn't have any idea about these things, even though she was the detectives on the case. Not that she was ignorant about it, but they didn't do it. Then he pointed out that Monte Carlo bill was only mentioned in the warrant. It's not something that you found at that house in 2023. He got in the point that, rubbing it in towards the end, that a lot of this was Clifford Mogg's job, and you weren't on it, even though you're the detective on the case. So you really don't know, do you? So once again, he's going to be rubbing this in the whole time, and he has to. He should. I see a lot of comments about him because he has this funky haircut. Hey, if you get a not guilty, who cares about it? Shouldn't be about. Should be about the case only. The state then rebuts that there's nothing weird about Mogg being an investigator, which the state ended up hiring him after retirement to be a consultant. Makes sense. Defense then came in again and did a recross. But Mogg didn't write a report before you. So he's pointing this home. There's work that they could have done. There's work that they objectively should have done. If you were going to charge this man for murder and you didn't bother filling in the gaps when you had a chance, no, they didn't. That's the answer. The next one was a Mark Hatton. He was LAPD. He was former Metro. He's a ballistics guy. And he basically authenticated the cartridges that were recovered at the scene. His job was to say that they all came from the same weapon. And he went over some of the techniques that they're using as far as the databases, or the database that law enforcement, or rather ballistics experts, used to show that bullets came from the same firearm, or at least the same type of firearm. And they did so. So, in other words, trying to show that these cartridges that we have, they're just not random cartridges that are on a Las Vegas street. I mean, you can, in the United States, in a big city, you can come across random cartridge from firearms that have been discharged. And that was a point of having Mr. Haddon up there. I don't believe the defense had any cross. The last witness, who was an interesting guy, he has a YouTube channel too with a few hundred subscribers. I guess he started it up around this time. Everyone's trying to cash in before they croak, you know, because Tupac's name is back in the media. So it's a Robert Ladd, and he was from the Compton Police Department gang unit. He was familiar with the Southside Compton Crips. He was familiar with the defendant Keefe D. He was on a first name basis with a lot of the gangs that were in Compton. Compton being a small place, and we're gonna get to that later because there's something from yesterday I wanna hit on. And you know, a lot of gangs in a small city, you know, like less than 100,000 people and like 50 gangs or something like that. So anyway, he was familiar with the defendant. He was familiar with Orlando Anderson, the one that, according to the defendant in his interviews, actually fired the shot, and also defendant's nephew. He remembers James McDonald, the Mob Piru grandpa, and his nickname was Mob J. He remembers Suge, said Suge was affiliated with Bloods, but he was never a gang member, a gang banger. So he establishes his credibility as someone with knowledge on the gang scene in Compton, California, and very generally about California gang life. He establishes the gang affiliation with various personalities, his expert opinion. He does give expert opinions, and defense could vet him outside of the presence of the jury, but they chose not. But that's beside the point. He said most murders are retaliation. So this was important for the state. He's saying most murders are retaliation. Remember, the state's saying that Keefe D and his nephew went and murdered Tupac in retaliation for what happened at the MGM Grand. And what happened at the MGM Grand was retaliation for what happened at the Lakewood Mall. So right now they have Compton gang detective, or rather someone on the gang task force, saying that the majority of murders a retaliation from some form of disrespect. He asked him about the Lakewood Mall incident. It's more of an expert opinion because it was about a chain snatching and a big gang fight. You know, they jacked up Foot Locker and all that. The whole place needed some renovations because it was a lot of ruckus. He mentions something. He said when Tupac was very interesting. He said when Tupac was shot, and it's interesting from my perspective that it goes towards the defense's case. He said when Tupac was shot, that same night, within a very short window, Reggie Wright Sr., who was chief of police or high-ranking police in Compton, California, Reggie Wright Sr. was saying the rumors that this person is affiliated with Southside Compton Crips. And he said after that, the violence spiked. 2 days after the shooting, there was a first murder. A 10-year-old girl got hit, or rather, first shooting, not first murder. Some guy named Darnell Grimm got shot. A little girl got shot. Darnell was a Southside Compton Crip. And the officers believe, you know, to the state's credit, they actually bring up that these individuals that got shot that day were from a different faction of Southside Compton Crips that weren't really cool with Dwayne Davis's. You know, they were like cousin factions or sister factions, and they had some falling out over some dumb stuff. So anyway, to the state's credit, they do point out that this was from a separate faction, but it was Mr. Ladd's expert opinion that to the Pirus, the Crips were Crips. It didn't matter. You know, one of those guys was involved. So it said there were during this time of this little mini war, this spike in tensions, there were 3 murders, 3 killings, and 10 shootings. And it was primarily between Mob Piru and Southside Compton Crips. So the Compton Police Department had no doubt in their minds that the Southside Compton Crips were responsible for Tupac's murder, and they executed a search warrant, and this was more in relation to the overall violence that was going down over there. But why I say this goes more towards the defense's case is that if the police officers believed that day that it was Southside Compton Crips, the testimony as a whole from the people outside of the police department that should be their antagonist, in other words, Suge Knight, Death Row, Mob J, so the Piru grandpa, I think his name's James McDonald, and other people from among them, even Reggie Wright Jr., they didn't show the kind of antagonism you would expect towards Dwayne Davis immediately after the shooting. Killing of Tupac and the shooting of Suge Knight. So if even the police thought it was Southside Compton Crips, the ones that are closer to that situation would be the Mob Piru, particularly those people that were close to Suge Knight and the people that grew up with Dwayne Davis, aka Keefe D. It doesn't make sense to me that Keefe D didn't face any repercussions from them, even though he's in the neighborhood. So to me, this goes towards the defense's case, but I don't know how every single jury member is going to think, and more importantly, we don't know what else the state has for us, and they have come with some surprises. Touch on that towards the end of this video. So the state takes the opportunity once again to enter into evidence some photos of Davis's house from that time, brings up a hotel receipt from Las Vegas and a court subpoena from Compton, California. It's for municipal court, probably a ticket or something. Also mentioned that Orlando Anderson, was a person of interest, and he was interviewed. They didn't get anything from him, nothing interesting enough to arrest him anyway. So the defense goes on cross. He brings up Ladd's book. Everyone's writing books, apparently. I question how much input that these guys actually put in it. I don't believe for a second that Keefe D took his time to write that book. No disrespect to the man, but we've heard him speak, and he's not that eloquent regarding his issues. I don't think he could have made a good narrative personally. He follows coaching too much, and I think that's what got him in this situation anyway. That and just trying to cash in like he saw everyone else doing, but that's beside the point. So anyway, on cross, he brings up, Ladd, you have a book, right? And you found a ticket to the MGM at Suge's house whenever you execute a warrant there, right? He brings up a letter from the Excalibur Casino to Orlando Anderson. So right now, the defense is established. You have specific presence in Las Vegas of Suge Knight. You have specific presence in Las Vegas to Orlando Anderson. And then he points out, you have some letters that you talked about y'all took from these homes, but where are they now? He doesn't know. They don't have these letters in evidence, even though you took them as evidence. So once again, this is where someone like me says, look, you all, state of Nevada, have various pieces of evidence, and then you left some of it out because it no longer exists. But there was a better time to come through with this while you had the information, but you sat on it, and now some of it is gone. And to me, this just means anything that gone, I'm gonna assume it in the defendant's favor, because this is what justice requires. How would I make assumptions against when you all had the opportunity before, and now those things don't exist? So fairness would require that I either give less weight to certain pieces of evidence, like the things from this search warrant that was executed in Compton, California, or that I make presumptions in his favor. You can't have it both ways, that we take all the evidence you have and assume that that's right and correct, and it goes towards the things you would have us believe. But then those things that you just happen to lose, we don't pay attention to that, and we assume that that doesn't go again. I have a problem with that. So anyway, even though they found evidence of Suge, outside of the fact that he got shot there, they found physical evidence that Suge had been in Las Vegas. They found physical evidence that Orlando Anderson was probably in Las Vegas, physical in the sense that, receipts. They didn't find anything that Davis was in Las Vegas. And then the defense points out, rightly, that this bill that you found from the Monte Carlo casino, it doesn't say Davis's name on it. You have all these things that say that say the people's name. You mention these things in connection with Davis, but none of it say his name. Is that right? That's right. That's true. And then Mr. Ladd makes an admission. Well, not an admission, but rather he answers when asked by defense counsel, and his answer is that if he found something related to the Tupac murder in those days, he would have called Las Vegas PD. He would have called Metro, but he didn't, because he didn't find anything that would have implicated Dwayne Davis. He talks a little bit about the other guys inside the vehicle, Big Dre. So they called him Big Dre. He's like 6'4", like 300 pounds. Terrence Brown, I think he was referred to sometimes as T. Brown. He was another suspect at the time, medium build guy. He talks about Anderson's death. Orlando Anderson said it was unrelated to what happened in Las Vegas. He said Dwayne Davis's house, he didn't find money or expensive things. So in other words, the defense, even though it's known that Dwayne Davis was a Crip and an older one, so he had some authority during that time, defense is trying to diminish that he was a big-time drug dealer, even though he'd been arrested various times for selling drugs. That's beside the point. So he also established that Compton PD didn't think Tupac was a gang member, despite his association. And he also points out that there were Crips in death row records. So once again, this is a secondary thing that the defense has. Defense wants to point out that all these people knew each other, and that there really wasn't the kind of antagonism that the state is making it out to be. And I do favor that interpretation as well, because you see Suge Knight being cordial, or rather you hear reports of Suge Knight, we've already heard testimony of Suge Knight being cordial towards Dwayne Davis, and even paying Orlando Anderson to testify in his favor. And someone just tried to kill me and kill my main artist and a good friend of mine that I'm with all the time, and now I'm gonna continue to be cordial with them, even though we grew up together. These guys played football together in elementary school. To me, it's highly unlikely. It's more likely that Suge was involved. So it's a difficult case. It's not a slam dunk for the prosecution, but things are coming out. against him and also in his favor. So I'm not convinced beyond a reasonable doubt yet. And lastly, the defense closes its cross by getting the witness, Mr. Ladd, to acknowledge that there was no implication that Davis was behind any of the shootings in Compton in the aftermath of Tupac's killing in Las Vegas. Now, on redirect, the state notes that detectives rely on defendants' admissions all the time. And this was a bad one for the defense because Ladd says, yeah, the majority of murders are solved because the defendant eventually admits it. So he's using him as an expert, without saying so, using him as an expert to give way to the notion that if Keefe D said he did it, well, he did it. Like I said, this is their entire case. Listen to the last video. Their entire case is Keefe D said he did it. That's the substance of their case. He said he did it. 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 He did it. That's their case right there. It's not a bad case, but like I said, there are holes in it that might not have been there had they not dragged their feet in prosecuting Keefe D. I mean, they had the chance, almost a decade ago, so more than 5 years ago, they had a chance. So he also rubs it in that if Davis is in the car when the shooting occurred, being that he's the oldest Crip in that car, and he says don't shoot, then the shot wouldn't have occurred, right? And he gets him to acknowledge that, given Davis's position within the Crip gang, within that particular crew, actually, that if he gave the order to shoot, then the shooting would have happened. Mr. Ladd acknowledges that as well. There's a little bit more of recross, and I thought it was interesting regarding Keefe D's spelling. He says, in your book, you spell Keefe D a little bit different. And so the reason why I bring this up, and it goes to a point I brought up in the beginning of this video, Keefe D is spelled differently on the jacket that was found in Davis's house versus how it was spelled elsewhere. And defense is always going to bring up these little inconsistencies in the state's case because I think that people would think that it's a slam dunk. So these inconsistencies are important even though they're not weighed towards the defense. It's not the defense's job to prove anything when his theory is reasonable doubt. Every single inconsistency is important. When you sit on a case, I keep repeating this, you sat on this evidence for so long. Are these papers that you lost when Compton PD got put under the authority of a Los Angeles County Sheriff's Office? This evidence that was supposed to get transferred that got lost in the mix, that's your responsibility. This other evidence that you're talking about, that notes from Detective Mogg that the detective that inherited the case doesn't know anything about, doesn't even know if they existed. That's you all's responsibility because you sat on this case and the evidence was fresher a long time ago. You should have hopped on it a long time ago and got this warrant. But that's another matter altogether. And then interestingly enough that they brought this up, I think it's important that the state did so, is Robert Ladd does not believe for a second that Reggie Wright Jr. was Bob Pyru. And he's like, no, he's a former police officer and then he was private security, but he would have been around Bob Pyru just because Death Row Records had a lot of those guys around them, but he was not Bob Pyru. Very important because a running theme of the defense, and it's something that ought to be put forward, is that Compton PD, and I think he brings in LAPD a little bit, they're on Suge's side. There's corruption there. It's true. There was corruption. They're on Suge's side. I can't say that that's true, but he does seem to be friendly with various Compton PD police officers, some of them high ranking. So it's important that the state wanted to bring that up. So like I said, today was mostly just authenticating photos and physical evidence by the state. We're still in their case in chief in this day 7. But there's one last thing I wanted to bring up. And last video, I spoke about the 3 reasons to doubt that Dwayne Davis killed Tupac Shakur in 1996. And one of those reasons I said was that in Dwayne Davis's proffers and interviews and books, he never mentions things from the shooting that weren't already publicly available information. And the state took a pretty big bite out of that yesterday whenever they had the producer, I think his last name was Dorsey. I want to say it's Dorsey, but sometimes I'm hearing Darcy, so I'm not sure how his name is pronounced. Well, anyway, this producer, who is very antagonistic with the defense, I mean, I don't know, it's like, producer, you're a lawyer, you're a detective, you're a producer. I mean, chill out, man. You're not on trial. Just answer the questions, okay? Anyway, during this time, the state asked one question in particular that really put on the spot the theory, which the defense hasn't put forward, but is important to me as an attorney. It put a hole in the theory that Dwayne Davis had not said anything in his interviews and in his writing that concerning the killing Tupac Shakur that wasn't already public information that could be independently corroborated. So 40 cal, everyone knew that. Orlando Anderson in the car. Everyone, knew Orlando Anderson was in Las Vegas because of that beating. White Cadillac, everyone knew that. So the state mentions to him, he said, you've been researching this case of murder for a long time as a producer and, I guess a documentary filmmaker and a consultant. You've done a lot of research on this case, right? He's like, yeah, no, man, I've done hundreds of hours or however much time, he said. And he said, did you ever read anywhere that on the scene, on the road behind Tupac, there was a white Sebring? And then Mr. Dorsey said no. So far, from the public sources, as far as detective reports and things like that, it's the state's assertion that there was never mention of a white Sebring. Why is that important? Because that's something that Keefe D mentioned in his interview, that they shot at a white Sebring that they thought was chasing them. Now, that white Sebring didn't have a bullet hole in it, unless I missed that part in the interview. But why that's important is because the one that mentioned that white Sebring was the one that testified, I want to say on day one, it was a Ms. Ingrid Stokes. And she was one of the girls in the white Sebring that Tupac had invited them to follow him to the club. So basically that puts Keefe D there, right? Well, no, not really. I mean, if you look at that reasonable doubt that exists, just say that the notion that Keefe D has not mentioned anything that could be independently corroborated regarding the 1996 murder. He hasn't mentioned anything besides what was publicly available information. Well, that notion right there, just imagine you have a plate of food. You have steak, you have mashed potatoes, you have asparagus, you have some dessert, you have drink. The state basically took a big spoon, went in the mashed potatoes, dunked it in there, just pulled out a big heaping spoonful of mashed potatoes. You could see that that something's been bothered on that plate. So that theory, the defense has to smooth that over. It doesn't 100% convince me that this wasn't public information because Compton's small. LA's small. If you're from there, my family's from New York. I've been to New York a lot of times. I always say, and I don't think a lot of people understand me, New York is small. It's one of the smallest places ever if you're from there. If you're not from there, it's huge. You just moved there, you lived there 10 years, it probably still seems huge. If you're born and raised there, it's small. Your grandparents might have known someone's grandparents that you hung out with at school. You never had an idea about that. I get the feeling, just judging by how many people here know each other and went to school with each other during this trial alone, that LA is the same way. Compton, 100,000 people. People talk about Compton like it's a different country or something. You're going to tell me these people didn't know each other. We've already established that people from rival factions grew up together playing football together. Now they're shooting each other in Las Vegas and getting their heads busted at the MGM Grand. So the point is that this girl, Ingrid Stokes, her homegirl already knew Tupac, and that was the one that was driving the Sebring. And, they're from this area as well. I'm not sure if they were from Compton or from LA, I've heard Watts thrown around once too. But it seems as, they're familiar with Compton. This place is small. These neighborhoods, when you're from there, you're born and raised there, you're there, it's small. Ingrid had given an interview before in 2016. I don't know if she mentioned the Sebring. It would be kind of weird if she didn't, though. But just the same, given that there was already a suspect there, they already thought Orlando Anderson was a suspect. They already thought within hours that Southside Compton Crips were involved. There was already retaliatory shootings from Mob Piru 48 hours after the shooting. Being that there was a little war that lasted like 10 days and then there was like 10 shootings and three murders. It's not unreasonable to me that this story about these girls, what do you think? They kept quiet about it? This whole traumatic thing happened. They saw someone get shot at. The police had them on the curb in their nice clothes getting all jacked up, for hours on end on the curb and then at the police station. And they didn't talk about that to anyone when they got back to Compton. Of course they did. So that's not a big thing for me. But the thing is, the defense, if they cannot put forward that was actually publicly available information, if they can't bring anything towards that effect, it's actually better for them to just leave it alone unless the state brings it up. If the state brings it up, then go ahead and acknowledge that, like, hey, you don't know about it. But the state never proved that this wasn't publicly available information. Was it publicly available information before today that, Suge Knight and Dwayne Davis used to play football? No, Dwayne Davis, you learned about that during this trial. So just because you don't know about it and just because it's not on TV doesn't mean it's not public in their zone. They're from Compton, they're from South Central, they're from Watts. They know what's going on in their neighborhood, and it's not even that many people that are from there when you're born and raised. Everyone seems to know people, or at least have like 1 degree of separation in between them. So to me, it's not that is good work on behalf of the state in bringing that up. That was something that needed to be addressed, and if it could have been addressed, and it was. So we'll see how that plays out tomorrow, day 8 of the trial, and it's still the state's case in chief. I'll be watching.